Yeah.
All right. Because we don't want to waste anybody's time, and we want to make good use of this time, we're going to go ahead and get started and let other people join. I will control mics as necessary. But good evening, and thank you for joining us for this estate planning seminar. As you guys have heard me say it over and over again, and hopefully that's one reason why you're here. This is important. If we're going to get real about anything, we have got to get real about planning for our future. We cannot continue to say tomorrow's not promised and then not plan for that tomorrow that's not promised. And so we have asked Mr. John Harris of Estate Planning for Louisiana for Louisiana. I knew there was a preposition there. I knew I was going to mess it up, but estate planning for Louisiana to come and talk to us about some basics. Now, there's probably some rabbit trails that you want to get into, and we will try to save all the questions for the end. However, if you think of a question, type it into the chat and we will get to it later so you don't forget your question. But we want to let him get through the meat of his presentation, and then we'll go into those different rabbit trails near the end of the conversation. But please, let's be interactive. Let's listen. Let's take notes. Let's do those things that we need to do so that we can be prepared for what could happen. And so at this time, I will turn it over to Mr. John Harris.
Well, thanks for having us. And it's always great to speak to groups. I spoken to a bunch of different churches and other organizations, and it's always fun to meet new folks and kind of, hear new things from folks, different questions. And so I look forward to answering y'all's questions as we wrap this up at the end. But I want to talk to you about really the basics of estate planning. And when you have that conversation, you really have to, start the conversation about what happens when you pass away. So estate planning is planning for when you're no longer here, when you've passed away, and you're looking at your spouse, your family, your kids, whoever it is, whoever you want to leave your stuff to, how are they going to receive it? What's the mechanism for that happening? And so there's two common types of estate plans. One's a will and one's a trust. And we're going to talk about both of those. But before we do, let's talk about what happens if you don't have a plan at all. And so in Louisiana, just like every state, there's a general rule that says if you own assets in your name when you pass away, it's got to go through probate, which is a term every state uses. Louisiana, we have a lot of laws that are nuanced or different than other states. And so we use a term succession interchangeably with the term probate. But probate and succession really is the judicial supervision, a judge supervising the process of assets being transferred from the deceased person's name to their spouse, their children, whoever they want those assets to go to. And so the legal term, if you have a will, it says that you pass away testate. And that means that if you don't have a will, that means you pass away intestate. And so whether or not you put a plan in place or not, meaning a will or a trust, there's always a plan that's going to apply. And so Louisiana, like every state, has default rules that govern what happens if you pass away without a will or a trust. And so if you pass away without a will or a trust, there's some rules that apply to how your stuff gets transferred. And the first thing you have to understand is that your spouse, your kids, your nephew, your brother, your sister, whoever's next in line to receive the assets are going to go meet with an attorney. And the attorney is going to ask a whole lot of questions. And the pastor was telling me a few minutes ago about how when he goes to Florida, his mom pulls out the binder and is, showing him all the stuff. And I imagine one of the things in those binders, because we make a binder too, for our clients, is a list of assets. And so one of the biggest things people have to do is try to figure out what the parents own, what the person actually, whether it's their child, their parent, their brother, sister, aunt, uncle, whoever it is that they're trying to handle their estate. One of the biggest things, the biggest, hardest things in the whole process is just determining what assets are out there. And, when it comes to that list, having things like life insurance policies, all the places that you have bank accounts, because a lot of people will go open up a bank account at one credit union or one bank because they got a good interest rate on a loan over there, and they'll have $100 sitting over there, and they've got 4 accounts over at another place because they got that going, and then they got some accounts over here. And so finding all that out can be a whole job in and of itself. But once they have all that information together and they sit down with the attorney's going to, gather all this information and figure out who's supposed to receive this stuff. And let me tell you about kind of one of the situations that happened to me, years ago when I was just starting practicing. I had a daughter come to me, and her dad had passed away. Her dad was not married. There was 2 children, just, this daughter that was in my office and her brother. And the dad, was not that he was probably going to pass away soon. And he told his daughter, listen, I want you to kind of be in charge of handling everything. You're kind of the smarter kid. There's always one kid that the parents kind of look at, say, you're the one. But, you're the one I want handling this stuff. I need you to sell the house, divide the proceeds between you and your brother. That should all be pretty straightforward. And, so when the dad did pass away, she came and met with me. She said that one of the neighbors had expressed some interest in buying the house for his daughter. And so they wanted to see what was involved with that. She said, look, it all looks pretty simple. And I said, okay, well, let's get all the information. We found out there was still a mortgage, and, like a month and a half had passed away, had passed since the father had passed away. Nobody was paying the mortgage. So the bank was already, threatening to foreclose on this mortgage, to get this all cleaned up. And she said, hey, it's fine. We'll just sell the house to the neighbor, and we'll be able to get this mortgage paid off, and we'll get what money's left over after the mortgage is paid off. The brother, unfortunately, had run into some problems, and he was incarcerated at the moment. And so explained to her, hey, look, it's going to be a whole process for us to get, the paperwork signed. We need to be signed. That's jumping through a whole bunch of roadblocks. But once we get that paperwork signed by him, we'll file it at the court. You're going to have to post what's called judicial bond that promises that you're not going to mess anything up or try to steal any money. But a month or 2, maybe a little bit longer, but we'll have it set up so that you're able to sell dad's house. In that process, she got called every single day by the, is she going to make a payment on the mortgage? She was upset about it because, she was afraid it was going to mess up her. I assured her that it wasn't going to mess up her credit. Her husband was upset about it because, she was digging into their money to hire me to do the succession. He had that money set aside to buy a new boat. And, he wasn't happy about that at all. So, it's a whole series of events that had to happen. And sure enough, we finally got it set up. And she's able to go through that process. Once the house did sell, we found out that dad had some credit card bills that she knew nothing about, and they had filed claims in the succession. And so we had to clean those up. And what should have been probably a very simple process ended up taking, like 14 months from, beginning to end to handle everything. The daughter was exhausted because it was like a second job for her, all of this stuff. And, she came to me afterwards. She said, look, I want to get my affairs in order. I want to make it simpler on my family. And we had conversations about, a will, and we had a conversation about a trust. What I feel is, kind of the minimum we should be doing, who you want to be in charge and who you want to receive this stuff. And there's a lot of other things we can do with the will. If there's minor children, we can, do some things to make sure that these minor children are not just receiving a big inheritance. If we've got kids, maybe they're adult kids that are struggling with a drug or alcohol dependency, or they have, tax problems, or they have a greedy, spouse who, may want to try to use that inheritance for themselves instead of letting the child use it as they want to use it. There's all kind of issues we can address in that will. But the key takeaway when we're having this conversation is that, whether you have a will or not, you still have to go through the process of a judicial succession, whether or not that will's in place. The will doesn't do anything necessarily to make the job easier. Now, you can guarantee that who's going to be the executor. You can name that person. And so in a lot of successions I'm doing, what's called a contested succession, there's a challenge, there's a fight between multiple people about who's going to be in charge. Who's going to be the one that's in charge of handling all the business? Is it the surviving spouse who is married to, the deceased person for 5 years, or is it going to be the kid, 65 years old? It can be a big battle there. Is the surviving spouse going to be able to live in the home that was between the children's deceased mother and their father, who's now deceased, or is that surviving spouse, who is the second, third, who knows, wife, going to be able to live in that home? And so these are all things that we can address with an estate plan. And the pastor was bringing up some examples, unmarried, but still living together and that type of stuff. We can address those issues with a will. And so as a bare minimum, we need to have a will. A will provides who's in charge and who do you want to receive this stuff. And we can put so much more into that. If you have minor children, you can provide who you'd want to be their guardian after you pass away. And that's one of the key things when there's minor children, specifying who you'd want it to be, because a lot of times there'll be a battle, between a grandparent and, a sibling, or, maybe it's between the father's mom and the mother's sister, trying to figure out who's now going to be the Louisiana term is tutor, where every other state they use the term guardian. Who's going to be the tutor for this minor child? And a lot of times it's not really, unfortunately, in this battle, it's not about who's going to be, the better parent. It's really a battle because the person that's the tutor is trying to get access to the money, and so making sure you have a good plan and protecting your child, make sure they're actually receiving the inheritance instead of this person who's trying to take advantage of the situation is very important. So that's a will. We can do a whole lot with a will. There's 2 types of wills. I'll tell you very briefly in Louisiana, only 2 types. There used to be more. There's what's called an holographic will. That's OLOGRAPHIC, holographic will. And that's a will that's completely handwritten. I will tell you, maybe this isn't popular with attorneys, but I will tell you, you don't have to have an attorney to prepare a will. You can sit down and write out your will yourself. Okay. Now, since I am an attorney, I'm going to tell you that's probably the worst idea that you can do. Okay. So whenever we have contested succession, one of the first reasons I would say we have contested successions where there's fights is people saying, that will's not valid. And I'll tell you, 95% of the time when it's an holographic will, a handwritten will, it's not valid. The court throws it out and says, we're not going to consider that a valid will. And it's kind of ridiculous because there's so few requirements for a valid handwritten will. It has entirely in the person's handwriting, and it has to be dated in the person's handwriting, and it has to be signed by the person. It can be on a cocktail napkin, as the pastor said earlier. It can be written on a basketball. It can be, the formalities are exactly what I told you. It has to be written entirely in by them. That's it. It doesn't say what kind of medium it's written on. You don't have to have any other special language. It just has to show an intent to create a will. And most people will do that by saying, this is my will, or using some other kind of fancy language to try to say that. So as long as we can determine that it's a will because of the language, it's entirely written in the person's handwriting, dated and signed, that's good. It doesn't require a notary. It doesn't require witnesses. And the biggest mistake that a person does when they do a holographic will is that they try to make it look more official by typing it on a computer. And that is the opposite of what a handwritten will is. They say, I have horrible handwriting, or maybe they'll put some stuff typed and they'll put some stuff handwritten. The court in Louisiana law says you and pretend like it's not even there in a holographic will. Okay. So I'll tell you, at a bare minimum, have an holographic handwritten will. Most of the time, there's going to get tossed out, but still having an holographic handwritten will than not having a will at all. Okay. The other type of will is what's called a notarial will. And this is what you get when you go meet with an attorney. A notarial will is can only be done by an attorney. So, if I have a client, I've had clients come in with something that they bought, self-help area, where they ripped off a page in the back and kind of filled in the blank. That's not going to be a valid notarial will. It normally lacks the requisite things that have to be in it to be a valid notarial will in the state of Louisiana. But will is entirely typed. It has to contain certain special language, but the key elements is that it's signed on the bottom of each page by the person making it. It's signed on the last, obviously, and it has to have a notary and 2 witnesses who observe the person signing it, and they sign their name as well. If you use, let's say that you leave everything to your wife, and then you use your wife as one of the witnesses of the notary, well, they are left out. They don't get what you left to them. Okay. As one of the witnesses or a notary, you need to, it needs to be independent third parties who aren't. Okay. And so notarial will is what I would say, it can be a very good option. But again, wills don't do anything to make the process successions faster, easier. It does protect children. If you want to put restrictions on when people receive stuff, how they receive it, you can specify for non-spouse or child to receive things, where in default Louisiana law, before, if you don't have a will, Louisiana law provides receives the stuff. Okay. And it gets really messy. It gets really, really messy based on whether or not it's community property or separate property. And that's, again, getting in kind of the weeds of Louisiana law. But you can have a situation where a husband and wife maybe dated for 10 years before they got married. While they were dating, the husband bought a house. It was their house. They always treated it as their house. They paid off the mortgage while they were married. But the fact that he bought it prior to the marriage makes it his separate property. And if he had children prior to that marriage, whenever he passes away, it doesn't matter how many years that wife of his has lived in that house, or of her paycheck went to paying down that mortgage, that house is going to the kids and not to the surviving spouse. Okay. And so at a bare minimum, having a will and saying what you want to happen in that situation is very important, very, very important. And that's where a lot of the messes come from. The worst succession I've ever been a part of, and I'll tell you because y'all are a congregation, was a Southern Baptist pastor. He was a pastor for 50 something years. His wife predeceased him, and she was in her 60s. But when, after many years of being single, he remarried, and there was a big fight between his children and that surviving spouse over the Bible he held every Sunday when he preached. Okay. So that surviving spouse was married to him. I can't remember, 10, 20 years, a long time. And the children obviously were around for a long time. And they both felt like they had a claim on that, on the preach about Jesus. And they fought for years about that deadgum Bible. They didn't care about what happened to the house. They didn't care about to the Bible. And eventually I got out of that succession because it just felt icky. So, your family, I want to spend, the next little bit talking about, how to make estate planning really work well. And so the best option these days, and when you actually sit down and talk to an attorney that does a lot of estate planning or successions, you'll find most people talking about trust. And the great thing about a trust, this isn't, I remember growing up hearing people having a trust fund, and that meant they're rich, and, the trust fund's paying for this and the trust fund's paying for that. That's not what we're talking about. Okay. This isn't a rich person trust fund. In Louisiana, we just don't have rich people like that. This is the average common person trust that I'm going to talk to you about. It's what's called a revocable living trust. I told you when we first started this conversation that the rule in Louisiana, just like every state, is that if you pass away with assets in your name, it's got to go through, and that's that very expensive process that takes a long time, where a judge says, this is who's going to receive this stuff. Okay. And you spend, like I said, the average is 11 and 13 months. The cost these days is between $3,500 to $7,500, per person. So if you have a husband and wife, to go through two successions, when the first spouse passes away, then when the second spouse passes away. So the only thing a person has when they pass away is a bank account. They've already sold the house, they've already sold the vehicles. All they have is a bank account. Bank account has $1,500 in it. And the kids come to my office and say, give me this money. The account's frozen. What do I need to do? We tell them we need to do a succession. But the minimum you see a succession cost in our area these days is about $3,500. So do you spend $3,500 to get $1,500? You don't, so it's for the kids to know that there's $1,500 sitting over there in that bank account that should be going to them, but they can't touch it. A succession would be required in order for that to go to them. So when we talk, let me change gears and talk about trust. I told you a minute ago that the rule in Louisiana is if you pass away with assets in your name, it's got to go through a succession. The way a trust works is you title assets in the name of the trust. And so they're no longer in your name. The terms that are in that paperwork, that is the trust, govern what happens at each stage of the process. Okay. So while you're alive, while you're healthy, while everything's going great in your life, we title the assets in the name of the trust. Okay. You're basically do when you pass away, but you're doing.
He froze, Pastor.
Yep, he froze.
Okay.
Let's see if he comes back. Let's see. He's still connected. All right, well, we'll wait for his system
No.
to. Linda, were you going to say something?
Oh, no, he's frozen.
Yeah, he just dropped off, so he'll be back.
Okay, he'll probably add back on. Yeah.
So, but while we are at this point, I do want to encourage you, if you do have any questions, please feel free to put them in the chat, and we will deal with them. And we will deal with them as it comes up. Okay, can't answer that right now. Okay. All right, and I got my first question. Thank you, Sister Smith. So, all right, we will give him a second.
You're welcome. I'm sure it's clear as mud, but I'll explain it more.
We will get there. So how's everybody doing since we got this? Yeah, that we will have him, Twyla. We will have him start back when he starts at the trust, when he gets back on with us.
See if this works. So anyway, I was telling you about trust.
John, I was just going to make sure if you go back to trust, that's about where you left us.
Okay. And so the rule in Louisiana, just like every state, is if you pass away with assets in your name, it's got to go through probate. And so the way a trust works is that we title the assets that are in your name that would require probate in the name of the trust. And now the terms of the trust apply. The great thing about a trust is that while you're alive, you're in charge of your trust. That's called a trustee. And so for a married couple, most of the time you see husband and wife being the co-trustees of the trust, meaning they're still in charge of their assets in the same exact way they were in charge of their assets before they were titled in the name of the trust. So they the kids aren't in charge. The kids aren't kicking you out of your house. Nothing changes in your taxes. Nothing changes in the way you manage everything that you own prior to this. But now it's titled in the name of the trust. And as trustee, you're in charge of managing those assets. Whenever the first spouse passes away, no succession's required. Okay. So if the surviving spouse says, listen, this, 4-bedroom home that we raised our kids in, it's way too big for me now. I'd really like to downsize and move into something smaller. She can, or he or she, most of the time the husband passes away first. So we always say she for the surviving spouse, but, she can sell the home without having to do a succession, without having to get the permission of the children, without having to go see an attorney, pay a bunch of money. It is literally, able to be sold at any point in time, with just her signature as trustee of the trust. Okay. So, talking about saving $5,000, talking about saving a bunch of time. I had a situation about a year ago where we had set up a trust for a husband and wife. They had plans to sell their home and move up north to be close to one of their children. And literally while they were loading the U-Haul, the husband passed away of a heart attack. And the closing was set for the very next day. And so the mother called me, or the spouse called me and said, hey, what's the deal? What do we need to do? Do we need to do a succession? I went and pulled up their estate planning documents. I said, look, you're trustee of the trust, the home's in the trust, show up at closing tomorrow. I know this is going to be a sad event for you, but you don't have to do a single thing in order to be able to sell this home. You can still continue doing your plans just as it was set up before. And so that was able to, make them be able to keep that transaction moving forward. And not a single thing had to be done. For most spouses in that situation, that is extremely reassuring that they're not having to go handle legal matters, have difficult conversations with their children. Hey, I need you to sign off on this. And the kid's asking, well, why, mom? I need to know. Tell me all about your business and tell me all about your finances. And, everything's kept private until the second spouse passes away. Okay. So once that second spouse passes away, we name in the trust document a successor trustee. And a lot of times this is an adult child. It can be anybody you want it to be, but a lot of times it's your most trustworthy adult child. And again, it's the job of that successor trustee to, most of the time, just simply dissolve the trust and distribute the assets to the people that are named as the beneficiaries. So in a situation where a husband and wife have 3 children and they say in their trust that each child is to receive 1/3 each, then, the job of the successor trustee is to go in, identify the assets, sell what needs to be sold, and distribute the funds to the beneficiaries, the children. And that's all done without having to meet with a lawyer, without having to wait 11 to 13 months for the court system to get their act together. There's no delay, there's no cost in, settling the trust, where you're incurring a great expense and spending a lot of time having to do a succession. If you have no estate plan or if you have a will. Okay. So I think Ms. Twyla may have asked earlier, are a will and a trust the same thing? And they're not. They're very, very different in what happens when a person passes away. A trust is very, very straightforward. What happens at each stage, where the surviving spouse most of the time is, stays in charge. Nothing has to be done. But when that second spouse does pass away, now we're distributing the assets to the beneficiaries. And I tell most of my clients, a trust can be settled in an afternoon. All the business that needs to be done, relating to a trust and dissolving it in most circumstances can be handled in the afternoon, where succession and probating a will and all that stuff can take 11 to 13 months on average. So a great tool, and for a lot of people, a trust works the way they think a will should work. If you knew how many times somebody came into my office and said, my daddy had a will and, the will says everything's divided between 3 kids. I don't understand why I'm having to hire an attorney, pay them a lot of money, and why I'm having to jump through all of these hoops in order to get the stuff put in our names. And that's just simply Louisiana law. That's what's required when a person passes away with assets in their name. So That's the big picture of all of this stuff. I know I moved pretty quickly through all of it, but I imagine that conversation probably prompted a lot of questions from you guys. And so I'm happy to answer any questions you have. If you would like me to talk about power of attorneys, which is also for most people a very quintessential estate planning, tool, I'm happy to visit about that. I'm happy to answer some questions related to trust about, specifically kind of what's done when, and what kind of, documents typically go with a trust. Or if you have questions about wills, I'm happy to answer those too. So give me a little bit of feedback about what you guys would like to hear maybe a little bit more about.
You said that there's like a will.
That's right. A notarial will
Okay. And the other one is
is an holographic will.
holographic. Okay.
The holographic is the handwritten will.
Yes. And the other one is what now?
Notarial, Notarial, notarial.
Okay.
And I will tell you guys, one of the things that I see very frequently in our part of the state is that people are, they go see, somebody that's got a sign out in front of their house that says notary, or a sign that says paralegal. And, they're going to them for estate planning advice. The first thing you should know is that only attorneys in Louisiana can give legal advice. And legal advice is when you're applying the facts of a person's situation to the law. Okay. So I will tell you, a notary can prepare a will, but what is envisioned by the legislature when they said notaries can prepare a will is back in the old days, they had pre-printed pages where you just filled in the blank. It was kind of like those Mad Libs. I don't know if y'all remember those growing up. Where you just kind of filled in the blank with an adjective or a noun, kind of thing. It's just like that. And that's something that a notary is allowed to do, is that they just, fill in the blank and do that. But that's not what most people need. The first thing that a person comes to a notary, attorney, whoever, and says, hey, I want to do estate planning, is they say, I've got a husband and I've got some kids. Okay, well, now there's facts. Now we're having to determine what is the best way to do this. Because you can do within a will, you can do things, 10 different ways. Are we leaving the right to use the house to the spouse for a little while, until they remarry or until they pass away? Or are we actually giving full ownership to the house to that surviving spouse, so that when they remarry, they can give it to their new girlfriend or boyfriend or new wife or husband, So that's where all the nitty gritty stuff comes into play, is how do you protect the kids and how do you protect your spouse is a big issue we have a conversation about in our office law. Yes, ma'am.
On the trust, it sounds pretty easy because you said you could do it in hours or whatever, but you set that up, like I would set that up now with my family.
That's right.
I would talk to my family and we would all agree. And then how do we get a trust?
Right. Well, the first thing I tell you is that your estate plan is your estate plan. And one of the biggest mistakes I see is people trying to do estate planning, by consensus. Okay. Because as soon as you invite other people to have opinions about your estate plan, they're always going to have an opinion about your estate plan. Okay. So, once you invite that conversation, to your kids saying, do you think this is the right thing for me to do? Or you think I should do this with my stuff? Or you think I should do that with my stuff? They're going to be coming to you every couple of weeks saying, hey, I have another opinion about what you ought to do with your stuff. So I'd encourage you to do your estate plan yourself. If you're married, you and your spouse should be probably doing this together if y'all have a good marriage and a good relationship and all that. But I would not include the kids in your estate plan while you're doing it. Now, some people choose to share their estate plan with their children once it's completed. Other people say they'll find out when I pass away, but that's going to be one common mistake I would tell you to avoid, is do not do estate planning through consensus. because you'll be paralyzed because it will never happen. No, you can't get 7 people on the same page. I don't care how close you are. Okay. So
Okay.
that's the first part. The second part is, yes, the best way to set up a trust is to set up a meeting with an estate planning attorney and sit down and say, this is what I want to achieve. A trust is set up during your lifetime while you're healthy. It's got to be put in place before you pass away. And so the 2 important parts of setting up a trust are the actual document and then titling assets in the name of the trust. As long as those 2 things happen, then a valid trust has been created, and you're able to avoid probate whenever you pass away. I see that Vicky wrote in the chat, does trust go through probate? And no, the whole purpose, the whole design of a trust is to avoid probate. Okay. So from the very beginning, they're fundamentally different in that a trust is designed to avoid probate, where if you have no estate plan, then your assets will go through probate when you pass away. If you have a will, it will go through probate when you pass away. So all good questions. What else?
I have a question.
Yes, ma'am.
Now, let me see how I'm gonna word this. This is a home that belongs to my grandmother. And
Okay.
when she passed, the family that was involved with her other kid signed the house over to her youngest daughter. So therefore, that home belongs to the youngest daughter. What I'm trying to find out is her sisters and brothers that signed the house over to her, are they entitled to any parts of the house when she dies?
Okay. So I'm going to tell you that I'm going to make some assumptions. I'm going to tell you what those assumptions are. So you said whenever your grandmother passed away,
Right.
that the house was signed over to
the youngest daughter. Right.
Youngest daughter. Okay.
All the other siblings signed the house over to her.
So
But the other siblings have kids.
Gotcha. So one thing that you're not saying here is whenever grandmother passed away, a succession was done. Okay.
Right.
So as long as when grandmother passed away, a succession was done and all of her children were placed in ownership of her home, meaning let's say there's 5 kids, they all own undivided 1/5 in that home. Okay.
Right.
And then after they all owned undivided 1/5 in that home, they said, hey, 4 of us are going to donate our interest to this one child. And they all put on paper in a valid donation and filed it at the courthouse that they were donating interest to this one child. Then that child owns it. It's the same thing as if I come to your church and I give you a $10 bill, do I get to control what you do with that $10 bill after that? No, I don't have any rights to that $10 bill. I'd be an Indian giver if I came to you and said, you should give that $10 bill to your pastor next week. No, that's your $10 bill, and it's the same way. If they gave that house to her, it's her house and her estate plan covers what happens to that house when she passes away. The siblings and nobody else has any interest in that home other than her.
All right. One more question.
Sure. Go for it.
To give a house to, say to me, is that the same thing as an act of donation? Can that form be used?
Absolutely. So, if the person that got the house is still alive, is still healthy, doesn't have dementia, has never had a stroke, is competent with it, then she can use a donation to donate that house to you. Absolutely. For the longest time, people tried to avoid probate or successions in Louisiana by donating everything they had before they passed away. And in some circumstances that can work. Not everyone, but in some that can work. There are times that donations done to avoid probate can be roped back in and force a succession, and that all ends up being very messy. But in most circumstances that can work, and it is something that ends up, it's not as clean as doing a succession or a trust, but it can, most of the time, the problems you end up seeing is that when that's done, a lot of times the person ends up owning two homes. The person who was donated the home, ends up owning two homes. Well, unforeseen to them is property taxes. So if you own only one home in Louisiana, you're allowed what's called homestead exemption, which means the first $75,000 of value of the home is not taxed.
Right.
You're only taxed on everything above and beyond that. But if you own more than one home, then you're taxed on the full value of that home. And so while that property is in, let's say, your aunt's name or your mom's name, she's probably not paying any property tax, or she's paying very little property tax because she has homestead exemption. But before she passes away, she donates that home to you to avoid probate. Now you own, let's say, two homes. You're going to be paying a $1,500 tax bill every year because now you have two homes and you can only have homestead exemption on one. It doesn't matter that your mom's still alive, still living in that house. So in a lot of situations, donating a house prior to death in order to avoid probate ends up being more expensive than if you had just done a succession. Okay. Another thing that happens more frequently, you'd think, is that mom donates the house to, let's just say the son, to avoid probate. And then the son goes through a divorce. And now the son's former spouse is trying to take mom's home. Or mom donates house to son, and then son gets in a terrible car accident and it's his fault. And now these greedy personal injury lawyers are suing, trying to take mom's home. Doesn't matter that mom's still living in there, that mom's 95 years old, and can't go live anywhere else. That's the house, that's the property they're going after to satisfy their judgment. So in most circumstances, my advice, just like most estate planning attorneys, is donating a property while you're still alive to avoid probate has more pitfalls than it does have success stories.
Well, what would you suggest instead of active donation, do the trust fund, set up the trust fund?
Yeah, doing a will or a trust will make sure that the house goes where they want it to go. A trust would be the way to avoid, a very messy and expensive succession. It makes it very fast and easy, but at a minimum, doing a will make sure that house goes where we want it to go, whenever the person passes away.
Okay, is that the living will? Let's use the living will for that.
Well, let's use our term correctly. So there's a will, last will and testament is one thing. And so I call last will and testament a will. The other thing is a revocable living trust. Okay, so those are the two terms. It's either last will and testament or revocable living trust. A living will is actually a whole different document. That's your statement on life support machinery. So if you're brain dead, never coming back, do you want them to pull the plug, or do you want to live there? Do you want it to be kept alive artificially via life support? So we're going to be careful not to use the term living will, since it means something else.
All righty, got you. Thank you so much.
Absolutely, Miss Patricia. Thanks for your question. I see Miss Eula Smith had a question. Are IRAs excluded from succession? There are 4 assets that don't have to ever go through probate: life insurance, 401ks, IRAs, and annuities. Okay. Those assets, whenever you set them up, you named beneficiaries when you set them up. Okay. So frequently a husband worked at, Bob's muffler shop, and Bob's muffler shop contributed to an IRA. So the husband now has an IRA. When that was set up, he named his wife as the beneficiary, and he probably named his kids as a contingent or alternate beneficiary if his wife isn't alive whenever he passes away. So in that scenario, let's say that, the husband is survived by his wife. All the wife has to do is wait for a death certificate to be issued by the state. It can take up to 5 weeks. And then that wife will send that that death certificate and a claim form to the IRA, and the husband's IRA will be transferred to the wife. She can put it in an IRA herself, where she, puts off paying taxes, or she can, cash it all in, pay a lot in taxes, and go on a great trip to Vegas. It's up to her.
What
So-
if they're divorced?
What if they're divorced? Is that what you asked?
Yes.
That's messy. That they should have cleaned that up a long time ago. Good luck. The better question is, what happens if there was only one beneficiary named, there's no contingent beneficiaries? What do you do then? Or if everybody named as primary beneficiaries and alternate beneficiaries passes away, what do you do? Well, in that situation, now this non-probate asset has to go through probate. Okay, so whoever would be the recipient, either through the state plan or through default Louisiana law, would be the ones that receive it. We see you eating, Twyla, and now we want to know what it is. Oh, she's gonna
Now,
type it.
Okay, there were some other questions that folks kind of
Yes,
jumped
yes.
through because my pastor had the questions, but he wasn't asking them. So now
Okay.
you got them.
I see it. So IRAs are excluded from succession, just like life insurance. One
Got that. Got
key
that.
thing. Miss Eula, I think I'm feeding back. So if you can mute your mic just for a second. There you go. So one key thing to know is a lot of people think if they have life insurance, that's what can be used to bury, them when they pass away. Understand that life insurance is going to take 2 or 3 months to pay out. You're going to have to wait up to 5 weeks in order for a death certificate to be issued by the state. And let's say the same day you get those death certificates, you're turning around and sending it to the life insurance company. It's still going to take them a while. So in most situations, doing what the pastor's mom has done, pre-planning your funeral, at a funeral home is typically going to be the best way to do that. And what's great about that is you can lock in a rate in today's dollars. You're not paying what it's going to cost for the funeral 20 years from now, which is going to be a lot more. You can go ahead and select all the things you want. You can have it paid off. That's the best way to do it. Or having money, having enough money in a bank account that your kids can access. And if we had more time, I'd talk about that. But have enough money in a bank account that your kids can access in order to pay for a funeral is another way to do it. Otherwise, you're just leaving.
Well, that addresses that other question that I put in about the savings account. The ownership sometimes says spouse and spouse. But if it says spouse or spouse, then either one of them have access to it, even if the other one passes. Is that correct?
Well, kind of yes and no. So in Louisiana, just like every other state, you can have 2 types of bank accounts. If the term or and is really driven more by how many people it takes in order to do something like sign a check or make a change. So in a bank account that says, Bob and Tom, it requires both Bob and Tom in order to sign a check or to, make a deposit, in order to close out the account, in order to make all the kind of required changes that an owner would do. If you have Bob or Tom, then in that scenario, either Bob or Tom can sign a check. So in most situations with a husband and wife joint bank account, you'll have husband or wife listed at the top of the check. And that means that either husband or wife can sign the check. The rule in Louisiana, and I guess I'll dig into it real quick. The rule in Louisiana, just like every other state, is that if there's no living person listed on a bank account, the bank account will be frozen. Okay. So most people are only kind of thinking in their very direct circumstance. They have husband and wife listed on bank account. And take a scenario where we set up a trust. Husband and wife are listed on a bank account. Most instances, we're not titling bank accounts in the name of the trust. Sometimes we do. But husband passes away first. Okay, bank account's not frozen because there's one living person listed on the bank account. But what happens when the wife passes away? Or what happens if husband and wife pass away at the same time? In that scenario, now the bank account is frozen. So my advice, just like most estate planning attorneys that do trust, is, hey, look, let's take an adult child or whoever we trust down to the bank and add them as having signature authority, which is the same thing as being an owner without being called an owner. Or in a lot of banks these days, they don't do signature authority anymore. You actually have to have this person established as an owner. Okay. So if we take an adult child down to the bank and add them as an owner on that account, now that account's never going to be frozen, or most likely not going to be frozen, because the likelihood of husband, wife, and child all dying at the same time is very remote. Okay, so we need to have at least one living person on a bank account in order for it not to be frozen, and we're good to go.
But can't you have a beneficiary on that account?
You're like reading my mind. And so I'll tell you, the biggest problem I see with bank accounts is when somebody sets up what's called payable on death. And payable on death was something that was created by Congress years ago. It says, if you actually read the law in it, it says that the bank's not liable if they give money to a person listed as payable on death. Okay, that is not an estate planning tool. That's a favor to the bank to keep them from being sued. Okay, so payable on death is just to benefit the bank. It's not an estate planning tool, and it in most circumstances causes a mess, because take a scenario where husband and wife have 3 kids and they add one child that they want to be in charge of stuff. This is what most of the time happens. We've got oldest son is going to be in charge of handling everything. So they take him and add him as payable on death. And then mom and dad pass away. And now the oldest son goes to the bank and he gets a check made out to him for the $10,000 that mom and dad had in their bank account. Is that what they wanted? They wanted that one son to be treated special and different. He gets $10,000. No, what they most likely meant was for that one son to share that money with the 3 of them. But that's not what happens when people pass away these days. You know, the son's going to hold on to that money. He's going to pay like 1 or 2 bills and act like he did a really noble job of taking care of the parents, but he's going to pocket, you know, $9,500 and pat himself in the back and say how good of a job he did and say, thank you, mom and dad, for giving me this special $10,000 treat. And the other kids are going to be mad because they know mom and dad said at Sunday dinner every Sunday that, you know, hey, listen, you know, the oldest son's in charge, but he's going to make sure that everything was going to be split 3 ways. And now these 3 kids are never going to talk to each other ever again. Okay. Payable on death is a horrible, horrible tool.
Yeah.
Okay. The best way to do it is, like we talked about before, you know, have a will, have a trust, specify what you want to happen to these assets whenever you pass away. We may add a child as having signature authority or owner on a bank account, but unless they put that money in that account, it's not theirs. Okay. So just because you have them listed as having signature authority or as an owner, it's not their asset. And, you know, it's still going to be governed by the estate plan. Just adding them an account keeps that account from being frozen, especially in a scenario like we've set up a trust and we're trying to avoid having to go through probate. The question Twyla put was, can you add both children? You know, I have husband and wife coming to my office all the time. And let's just say they have 3 kids, and the mom, it's always the mom says, you know, I say, who are we going to name as successor trustee, or who are we going to name as the executor? And they say, oh, any of my kids would be good at this. All 3 of them are so smart and they're so sweet and they're so great. And I don't want to hurt any of their feelings by picking one of them, not the other. So can we put all 3 of them as the successor trustee or the executor? And I tell them, absolutely not. That's a terrible idea. Okay. So we want one cook in the kitchen. We want one person in charge. We don't want, just like we talked about earlier, we don't want to do estate planning or estate settlement through committee. We want one person that's handling the job so that only one person is, you know, making decisions. And we can name people in order. We can say, we'll put oldest child first, we'll put second child second, and youngest child third. But a lot of times that hurts the poor mama's feelings. And so we have a conversation about it. I say, you know, because I have 2 kids, and if you have multiple kids, you'll identify what I'm about to say. I tell that mom to think about which one of those children was the hardest to raise. They're probably all great now, but when you were raising those kids, who was the jerk? Who was the one that you had to run every day to do all the stuff and da-da-da? That's the one we're going to pick. If you say any of them would be a good person to handle, you know, the executor or successor trustee, pick that kid that was a little bit more work, a little bit more trouble growing up, and make them do a little bit of work in order to get their inheritance, where the other kids get to sit back and do absolutely nothing. Okay. So that's how I settle that conversation, is just pick that one and let the other ones just sit back and enjoy not having to do a single thing. And the mama thinks that she picked one, and the other one's going to be hurt. The two that don't have to do anything are going to sit back and say, Mama loved me. She didn't make me have to do a single thing. All I got to do is go to the mailbox and get a check, and it's all done. It's all great. So yeah, that's how we handle that. We're not going to put more than one person as power of attorney at a time. We're not going to put more than one person as executor. Not going to put more than one person as a successor trustee. It's always one cook in the kitchen, one person that's making the decisions. You'll ask, what is the process to change from a will to a trust? You sit down with an estate planning attorney, and we set up the trust, and then we'll go in and we'll destroy the old will. I had a client over in Arcadia who was never married, never had any children, and she did not get along with people or her family very well. And when I met with her, she was 85 years old, and she pulled out a shoebox that was filled with like 150 old wills. Okay. And she said, I want you to do a new will for me because the person I had named as receiving all the stuff is a jerk now. And, I don't want them to get this stuff anymore. So, I want you to do a new one for me. And you know what happens when you have that many old wills? Okay. Here's what happens in the modern era. Somebody's going to find that shoebox of wills, and they're going to dig through it, and they find the one they like, and they're going to save that one. They're going to destroy the rest of them. Okay. So we always destroy old wills. We don't give a bunch of copies out to people. Okay. Especially kids. If you're leaving one out and not the, we don't make a bunch of copies. Okay. We have one original. If we change it, we're going to destroy the old one and just have the new one, because we don't want people going in and cherry picking an old one, and discarding the new one whenever you pass away. So, all right. We're running up on about an hour. Y'all have any other questions? What else can I answer for you?
John, one thing that I want to make sure of is if we have a will, it's going through probate, no matter what the situation is. When somebody dies, divorces, married, single, it's going through probate.
That's right.
Okay.
Absolutely true.
Or succession.
Yep. That's right. So
Okay.
Probate succession means the same thing. It's just Louisiana term versus non-Louisiana term. If you have a will that you set up, and then you say, I want my spouse to receive everything, and if my spouse doesn't survive me, it goes to my kids, and then you later end up divorcing that spouse, and you never change your will. This is like one of the few times Louisiana law actually makes sense. It says that you just kind of discard the fact that that spouse was listed as receiving all the stuff. Okay. There's actually a law on that. Now, if you have a will that you set up and you say, I leave everything to my former spouse, you're already divorced. In that situation, they would still get it. But another very interesting thing about Louisiana law, if you give a child up for adoption, you have no rights to inherit from that child if that child predeceases you. Okay. So under default Louisiana law, intestate law, you would have a right to inherit from your children if they predecease you. But if you give the child up for adoption, you don't get to inherit from that child. However, when you pass away, that adopted child can inherit from you. Okay. So if you have no estate plan, and let's say you end up, let's say that a person has a child in their teenage years, gives that child up for adoption, and then goes on, gets married, and has 3 children of their own, never has an estate plan, and they pass away. All 4 children are going to split those assets equally. Okay. So if the adopted child knows who their biological parent is, they can inherit from them in the same way that the, I don't know the correct term, legitimate children, non-given up for adoption children inherit. They have the same rights. So an adopted child can inherit from their adoptive parents and from their biological parents. It's really, in my opinion, interesting nuance of Louisiana law. So the only time that a will would not go through probate is if the only asset you own is a vehicle. If the only asset you own is a vehicle, and in your will, it specifically states that I want my vehicle to go to my son, my spouse, the Red Cross, whatever. That's about the only thing that Louisiana law has made easy. You can take a copy of the will, the title, death certificate down to DMV, and they'll retitle the vehicle. That's the only time that a will would avoid probate. In every other circumstance, you know, if you own a bank account, even if the bank account's not frozen because you have somebody else on it, okay? If you've got clothes, if you've got personal effects, if you've got jewelry, if you've got, you know, whatever it is, it's got to go through probate. The only scenario where a will would avoid probate is if you just have a vehicle.
Now, I do have one question. Does that vary by state?
Yes, I'm just telling you Louisiana law.
Just Louisiana, okay.
So there's, in other states, they have made their laws so much more accommodating to doing estate planning. So you can do stuff called life estates in other states where when you purchase a home, you can specify who receives it whenever you pass away, and all kinds of, we just don't have that in Louisiana.
Okay.
And a neat thing about trust, while you're bringing up other states, so if you don't have a trust, let's say that you pass away intestate, meaning without a will, or you pass away with a will, you have to do a succession or probate in every state where you own assets. Yeah. So take a scenario that, you know, you own, let's say that you inherited some minerals from your dad in Texas, you know, so your dad sold the land, kept the minerals. And so when he passed away, you got the minerals in Texas and you owned your home in Louisiana. Well, whenever you pass away, we have to do probate in every state where you own assets. Okay. Louisiana is about the cheapest state that you're going to be doing a succession. If you take the scenario that you own those minerals in California, or you own an asset in California, the minimum cost that I see these days for a probate in California is about $12,000. Okay. So you're doing a succession in Louisiana and you're doing a succession in the other state. What's great about a trust is that you can put assets in any state in the trust and avoid probate in all the states. So for a person that owns, you know, assets in other places, it's a great tool to avoid a whole lot of time and expense, you know, and avoid probate is with a trust. Well, I really enjoy visiting with you guys. I know that Ms. Linda has my contact information. Y'all are welcome to email me. You're welcome to reach out to the office. I'm happy to visit with any of you if you have more questions. Always happy to help you guys or anybody else in the congregation set up a estate plan if you're interested in that, or we can help with a succession if that ever comes about. You know, I'm always happy to answer questions. If you email me, I'm, you know, happy to shoot you an email back just to give you a, you know, quick kind of opinion on what's going on in circumstance. It may require a follow-up phone call to get certain facts, but you know, I always enjoy visiting, and you know, let me know if I can help you guys out in the future.
Hey, John, thank you. Thank you for the information. I think it was great. We might be calling you again, maybe just to go, you know, spend some time in one of those rabbit trails. But and I got to tell you, because my mom pushed on us, hey, get your will done, get your will done, get your will done. I really wish I had talked to you first so I could have got the trust done. But no, this was amazingly informative. And we really do appreciate you making time for us and answering all our questions and having to watch Twyla eat. So before you got to eat your dinner.
It sure looked good.
My grandson took it from me.
That's what you get. That's what you get.
You get for eating in front of people.
So
thank you, John. Thank you so much.
Thank you. I do want to thank everybody who took time to log in. I especially want to shout out to Sister Vicki Smith logging in from down south. Wonderful to have you online with us as well. And like I said, if you guys didn't have any more questions, we've got the contact information, and we will try not to run you into the ground there, John.
It's fun.
You sparked something in us, and I think it's a good thing that's been sparked. So thank you very, very much to all of you, my brothers and sisters. Please pray for your pastor, because I'll be doing that panel thing tomorrow, and then driving to what's that place, Delhi, on Saturday. So if you would please keep me in your prayers, I would greatly appreciate it. But John, thanks again, everybody. Good night, and God bless you.
Bye.
Thank
Great
you.
information.
Yes, thank you.